Good morning, all. It looks like most of you have signed in successfully now. Welcome to the latest in our series of private wealth webinars. This morning we're going to be concentrating on will planning for business owners. The session is being recorded, and we will arrange for you to be sent a link to the recording at the end of the session. It will also be available on our website. Hopefully you'll be able to see, and hopefully you'll be used to the Q&A function. So if you do have any questions, please post your question in the Q&A function, and we will look to address those questions at the end of the session. So we're going to allow 5 minutes at the end of the session. Those questions won't be able to be seen by all the participants. They'll only be able to be viewed by myself and Junaid. And that leads me on to the speakers for this morning. So there is going to be myself, John Grundy. I'm a partner in our private client practice at Mills Reeve, and I'm joined by Junaid Haroon, who is a partner in our corporate practice at Mills Reeve.
Morning, everyone.
So without further ado, let's just have a quick look at what we're intending to focus on over the course of the next 20-25 minutes or so. So the sessions on will planning in particular for business owners, and I'm going to be talking about the importance of structuring your will appropriately. We're going to run through a case study, and in particular that's going to include some of the tax reasons, the tax mitigation reasons, as to why, if you put the right structure in place, it can help to save a considerable amount of tax, particularly inheritance tax, for the benefit of your family. I'll also touch on some of the control and wealth protection points before passing over to Junaid, who's going to run through a few of the corporate considerations as well. In terms of the timing, we plan to wrap up by 10:30. As I say, we're looking to allow 5 minutes for questions at the end. Okay, so let's just kick off with tax, with inheritance tax. And I'm sure you'll all be aware that inheritance tax is charged at a rate of 40% on all of your assets that do not qualify for any form of exemption or relief. So all of the assets in your estate added together, and there's a potential liability of 40% inheritance tax unless an exemption or relief does apply. There's a couple of very important reliefs that we will talk about today. One's spouse reliefs or exemptions. One's spouse exemption, so assets passing between a married couple can pass free of inheritance tax. And the other one that we're really going to focus on is business relief. Now, business relief is available at two rates, either at 50% or 100%. So either full or half relief for inheritance tax purposes. And it's available against certain business assets. And I've just summarized those in a couple of bullet points. So you get complete relief, 100% relief, if you own an interest in a business, or you own 100% relief if you've got unquoted shares in a business. And by business, we're talking about trading businesses rather than investment businesses. And also 100% relief for most, not all, but most alternative investment market, AIM market listed shares, if they're not listed on another main stock exchange. So it's a very, very generous relief. We also have 50% relief. You don't tend to see this too often, but for those that are lucky enough to have majority control of some listed shares, then potentially you're looking at 50% relief. There's also 50% relief applies, where you quite often see it, is If you personally own property which is used by your business, then again there's potentially 50% relief on that on the property owned for the business. A really important criteria so far as business relief is concerned is that you need to have owned that asset for at least 2 years. So if, as we're commonly talking to clients about the shares they own in a trading business, they need to have owned those shares for at least 2 years in order for the relief to be available. So I'm going to talk through some of the conversations that I would typically be having with business owners in relation to the passing of their shares on death. And if we just start with perhaps the most common scenario of advising a married couple. Now, your starting point is that assets that pass from the first to die to the surviving spouse on death are going to pass free of inheritance tax owing to the spouse exemption rule. But assets that qualify for business relief, you don't have to pass them to the spouse because, as I've explained, they qualify for relief, 100% relief in most instances, many instances. If you structure your wills appropriately, it's possible to benefit from that business relief, not only on that first death, but also on the second death in relation to the same assets. In other words, benefit from twice the relief, or double the relief. And I'm going to go on and illustrate that by way of an example, by way of a case study. So here on the slide, you'll see I've got John. A very simple fact. I've got John. He's married. He's got a couple of children. He's got a son from a previous relationship, from a previous marriage, and he's also got a daughter with his current wife, Jenny. John's main assets include the shares he owns in a trading business, which he actually runs with Jenny, and those we're told are worth 4 million. And those do qualify for business relief. He also owns a portfolio of investments managed by a discretionary investment manager, and those are also worth around 4 million. And he's got the family home worth a couple of million. So John's got a large estate around 10 million there. He's worried about inheritance tax. He wants to do what he can to mitigate inheritance tax liability, and he wants to maximize the benefits that business relief, as it currently stands, as is currently available, when he's thinking about structuring his wills. His objectives are really to provide for Jenny. Number one priority is all about his wife, and then ultimately he's looking to benefit both his son and his daughter. So he's looking to benefit those two children on Jenny's subsequent passing. That's what he's got in mind. So let's just have a think about the assets comprised in his estate and the conversations that we might be having with regard to the will structure, or the structuring of John's will to meet his objectives. So firstly there, and in the top box, we've got those assets, the three different types of assets. So we've got the business assets, the shares in the trading company that we're saying qualify for relief at 4 million. And we've got his investments, his stock shares and investments, also worth around 4 million, and the other assets in the form of his property interest. So that's his estate. And then we look at the bottom half. The question is, well, how do we structure his will, in particular with tax efficiency in mind and to meet his objectives? So he's looking to provide for Jenny and ultimately provide for the kids. So as we talked about, what we could do, and we could establish, is we could establish a single family trust. And I make reference to it being a single trust because that's very important, as I will go on to explain. So we could have a family trust created under the terms of his will, and that family trust could have two sub-funds. The first sub-fund could be on discretionary terms, discretionary trusts. So in other words, the trustees have got discretion over both the income of the trust assets and the underlying capital. And his shares in the business could pass on that into that discretionary fund. No immediate loss to inheritance tax because of the availability of business relief. The other fund would be a life interest fund in favour of Jenny. So Jenny is his wife. The inheritance tax rules provide that the funds, that the assets passing into that life interest trust in favour of Jenny will be treated as belonging to Jenny for inheritance tax purposes. So they will be aggregated with her own personal assets on her subsequent passing. Because of that, they qualify for spouse exemption. So the 4 million investments and the 2 million in the form of the house can pass into that life interest fund in favour of Jenny and can pass free of inheritance tax on John's death. So we got no inheritance tax at that stage, and by directing the business assets to that discretionary fund, it means that if they're sold or business relief is no longer available in the future, those assets are actually kept outside of Jenny's estate for inheritance tax purposes. They're not treated as belonging to her for inheritance tax purposes. But all of those funds are available for Jenny's access, Jenny's use, Jenny's enjoyment, Jenny's benefit. A really important point and a really important conversation with John is who is going to act as the trustees. Because this trust that I've just described is a flexible trust, and John's objectives are to, yes, number one, provide for Jenny, but ultimately, number two, he wants those funds to be split equally for the benefit of his son from that first marriage and the daughter they have between them. So the importance of selecting the right trustees to achieve those objectives, it really is critical, and I couldn't underestimate how important to have a full discussion. There's various options. You can include family members, professionals, a combination of the two. It may well be in a scenario such as this that we may end up with the likes of Jenny plus a Mills Reeve Trust Corporation, so plus the independent professional trustee to make sure that his wishes are implemented, and also to give Jenny control and a voice, because that's his number one priority really, is to provide for Jenny while she's still living. So that's if you like a stage one in terms of the framework of the will, is to have a single family trust with those two sub-funds. The position could get better from a tax point of view, though, if we look to reuse those business assets. So what we may consider doing is we may consider swapping the investments with the business assets. So the business assets move over into the life interest fund for Jenny, and the investments, which are a chargeable asset, were a chargeable asset in Jenny's estate. So the investment stocks, shares, investments, whatever form they may take, they're potentially liable to inheritance tax on Jenny's death. But if we swap those assets over from the discretionary fund to the life interest fund, as far as the business assets are concerned, there will be, the first point to make here is that because there is a swapping of assets within the same settlement, it's within a single trust, and they're not moving from one trust to another trust, we're not going to have to worry about capital gains tax. Typically, if assets are moving from one trust to another trust, you have to think about what's the capital gains tax exposure going to be. And despite the fact there would normally be the uplift in the market, uplift to the market value as at the date of death to wash out any capital gains tax liability on death, it's not uncommon in the process of administering an estate for there to have been some movement in the asset values. So by the time you come to considering making such changes, implementing such planning, there to have been a shifting in values, and that could trigger a capital gains tax liability if you had separate settlements. So it's one of the reasons we tend to structure this as a single trust. So there's no capital gains tax in terms of swapping those investments and the business shares. It's also beneficial from a stamp duty perspective. Again, these assets are staying within the same settlement rather than being transferred from one settlement to another, and therefore the stamp duty, there should not be stamp duty, or indeed stamp duty land tax if we were talking about property being on one side of the equation, applying. So this planning, this second stage, can be implemented without loss to tax. And the advantage of doing so is that those business assets can effectively be reused again. Those business assets that qualify for relief can be used again on Jenny's passing and qualify for relief to achieve the tax saving. So if we just look at the inheritance tax analysis, the investments held in that discretionary fund are not going to be subject to inheritance tax in Jenny's estate. So that saves, if they stay at the same value, it saves 1.6 million, doesn't it? 40% of the 4 million. It wouldn't be right, though, for me to say that that's a direct 1.6 million saving, because assets that are held in trust, as many of you will know, are subject to their own inheritance tax regime. And in simple terms, that equates to a maximum 0.6% inheritance tax levy every year. So every 10 years, it's a 10-year regime, every 10 years, that could amount to up to 240,000 in inheritance tax. So it's likely that some inheritance tax will be payable on those investments within that discretionary fund, but considerably less than the 1.6 million that would otherwise arise on Jenny's passing. And then if we think about the business assets, well, Jenny does need to live another 2 years from that swapping of assets in order for them to qualify, in order for them to meet that 2-year test. But if she continues to hold, or if the trust continues to hold those shares for 2 years, then those shares, and the rules do not change, then those shares will qualify for business relief on Jenny's subsequent passing. As an alternative to that, and if we did change the facts slightly, it's not uncommon for clients to say to me, well, I would like the shares in the business to pass down to either my son or daughter. And let's say in this scenario, let's say the son from the first marriage worked in the business together with his father, together with John, and John's wish was to pass those shares for the benefit of his son. Well, with that in mind, I would still advocate this same structure, because if John had just provided under the terms of his will for those shares to pass directly to the son, then we potentially miss out on that double saving that I've just described. Whereas if it was still structured in the same way, and then the trustees exercise their powers to move on the shares in favour of the son, a couple of years post-death, then we've potentially created that double saving for the overall benefit of the family. So sometimes it involves a little bit of creative thinking to come up with the best solution for the client. I'm a little bit conscious of time. I'm not going to labour the point. The savings are significant from an IHT perspective. There's also the CGT and stamp duty, or indeed stamp duty land tax potential savings with that single trust structure that I've just described. I haven't really focused on the asset protection benefits, but we have got a session coming up on the 8th of July, which is a protecting family wealth session that in particular is going to talk about some of the benefits of assets being held in trust from an overall bloodline, from an overall wealth protection point of view. One point I would just flag is that one of the great things about trusts is quite easy to bring to an end if it's decided that either the protections that they offer are no longer needed, or there's some change in the rules moving forwards, or there's no need, or there's a change in personal circumstances. So Jenny no longer needs access to some or part of the funds. And at that stage, you'd stop any form of further inheritance tax accumulating within the discretionary fund. So all of that tends to result in pretty happy clients, because there ends up being a pretty large tax saving for the benefit of the family. And that's all I was going to say. I'm going to pass over to Junaid now to just flag some of the main corporate considerations. Junaid.
Thanks, John. Just a quick reminder to everybody, we will have a few minutes at the end of the session to answer some of your questions, so please do submit them via the Q&A tab. I know a few of you have already. It'd be great to see a few more in there. What I'm going to do in the next 5 minutes, hopefully, is give you a very quick whistle-stop tour on some of the key issues that we see crop up time and time again when advising business owners, predominantly in the guise of will planning, albeit the first point is just good corporate governance. And it's the one tip I say to all my clients. Now, most SMEs that we see when they come to ask for advice, first thing we do is look at their constitutional documents, and it's not uncommon for us to see that the Articles of Association are based on Table A. Typically, that's either Table A under the Companies Act 1948 or the 1984 Act. And that's absolutely fine. I suppose what I would flag at this stage is the 48 Act and the 84 Act were designed under a regime where all companies were treated the same. So whether you were an SME or a large corporate, generally speaking, the regulatory regime that applies under those acts is identical. And it's probably fair for me to say that the vast majority of our clients, when they come to us, have never seen their articles or have never read them. They were something that was done by their advisors on incorporation, and they don't look at it when they're working on a day-to-day decision making. Now, the Companies Act 2006 introduced the model articles, and the one thing the Companies Act 2006 did do is it took us a slant to ensure that the regulatory regime that applied under the model articles, and indeed under the 2006 Act, was very much heavily weighted towards SME businesses. So there was less regulatory red tape involved, and actually the model articles introduced several really useful exemptions if you're running an SME. Why is this important? From a legal technical standpoint, if you've got Table A Articles of Association, it is almost highly unlikely that you are complying with all the regulatory red tape on a day-to-day basis when making decisions in your company. In theory, that means any decisions made would be ultra vires and against the law because you're not acting with your constitution. We generally say to clients that one of the easiest wins you can do from a corporate governance perspective is if you have Table A Articles of Association, you should consider upgrading them to a form of the model articles, whether that's the model articles as they're incorporated under the 2006 Act, or whether they're a set of articles based on the model articles, but tailored towards your particular company. So that's point one. That's quick win number one. Point two is around those companies where you have a sole director and sole shareholder. Again, it's a structure that's quite common in clients that come to see John and I. And the one warning I would flag here, and it links back to the Articles of Association, is if you are a sole shareholder and sole director in a company, and you are not going to transfer your shares into a trust, as John's just described in his example, prior to your death, if it's going to happen on death, I would strongly advise that you read your Articles of Association very carefully to ensure there is suitable provisions in there which allow a substitute director or a new director to be appointed on your death. Now, John and I have seen plenty of examples where people think they have this wording in there and it's either not in their Articles of Association, or unfortunately, it's just been drafted incorrectly. And the problem that gives us is it means that we are unable to appoint a director to the company on your death without having to go to court. So we have to apply to go to court and get a court order to appoint a director. Now, in the intervening period between date of death of the sole shareholder and granting of the corporate order, the company is rudderless. It doesn't have a director on board, which means it legally cannot make a whole host of decisions from basic things such as authorizing payroll, entering into contract, paying your water cooler distributor. It can't do anything. And that, depending on the length of that gap, and unfortunately it is determined by court schedules and when we can get a hearing, you know, that gap, that paralyzation, the incapacity of the company during that period of time could be catastrophic for its business prospects in the future. So if you are currently a sole director, sole shareholder of a company, urge you to do one of two things. Consider appointing a second director now, so we don't have the issue where on your death there will be no director left in the company, or alternatively, please do check your Articles of Association very carefully to ensure that you've got the provisions needed to allow a second director to be appointed on your death. The third bullet point there talks about future plans, and actually what I'm talking about here is where we have clients who come to us who are one of a number of shareholders in a company. And broadly speaking, those clients fall into one of two camps when looking at their businesses in the future. So the first camp is, as John's case study showed, you have a client who owns shares in a business. They want the shares to either be held in trust or to provide an income for their beneficiaries after their death. And that's absolutely fine. For those clients, what we would suggest now before death is to have a look at drafting a shareholders agreement, which talks about what rights apply to those shares that they hold. And this is incredibly important in the sense that if the purpose is to ensure that those shares continue to attract an income and the business continues to be viable post-death, then what you probably want to do in that shareholders agreement is include certain matters which the company cannot do, or the surviving shareholders and directors of the company cannot do without getting the consent of the entity that holds your shares, whether that's a trust or a benefit, however you've structured your will. And we'd look at doing things, you know, we'd focus on issues which go really to the heart of the shareholding equity. So things like declaring dividends or taking cash out of the business, or an unnecessary amount of cash out of the business, just to ensure that your aim of providing future income and ensuring those shares contain value and continue to retain value and hopefully increase in value after your death, to ensure your beneficiaries have income to spend. So all of that protection should be looked at in the shareholders agreement. For the other camp of clients in multiple shareholder companies, so they say to us, actually, on my death, I don't want my estate to have any shares. I'm perfectly happy with they're receiving cash for their shares, which is absolutely fine. The problem we have is on the death of a shareholder, there is nothing to guarantee that the surviving shareholders have sufficient cash to be able to acquire the shares of the deceased shareholder. And one of the easiest solutions here is to put in a cross-option agreement between the current shareholders. And for those of you who don't know, a cross-option agreement is essentially a contract at law which says, in the event of death of one of the shareholders, the other shareholders will commit to acquiring the shares of the deceased shareholder. Behind the cross-option agreement, each individual shareholder will get an insurance policy, and the beneficiaries of the insurance policy will be the other surviving shareholders. So what this mechanism ensures is that on the death of shareholder A, the insurance company will pay out proceeds to shareholders B and C. Shareholders B and C will then be able to use those proceeds received from the insurance company to buy shareholders A's shares from his estate, which will result in, or his PRs, which will result in shareholder A's estate receiving the cash for the shares, and shareholders B and C receiving the shareholders A shares in the company and therefore being able to run the company as they see fit. Now, I'm conscious of time. We've run slightly over. That is a very quick whistle-stop tour. And we'll move on to, hopefully, John, we've still got some time for some questions.
Yeah, I think for those that are able to stay with us, I think we'll just keep questions to 3 or 4 minutes. But we've got a few that have come in. So if I just kick off with those, I think most of them are probably more aimed at me on the tax side, Junaid. But you'll be delighted to hear.
I'm delighted to read that, John. Honestly,
let's just pick up on a few of those questions for those that can stay with us. One of those is where will these property qualifying for business property relief only into a discretionary trust? What happens to accepted assets, for example, excess cash? That's a very good question. So quite often you do have some form of accepted assets, so some form of surplus cash to the business's needs held within the business, which would reduce the 100% relief. And let's try and put some figures and numbers around that. So in my example, so John had a business worth £4 million. Let us say there was £400,000 worth of accepted cash within that business. That would mean that 3.6 million would qualify for business relief, but 400,000 would potentially be chargeable to inheritance tax. Quite often the way you would draft the will, or the way you would structure your will, is to capture the whole lot. So you capture all of the shares that qualify for relief. So you would, on the face of it, then have a potential exposure to inheritance tax. Now, one of the things you also include, you quite often include, is an amount up to the nil rate band allowance. So it may be that on John's death, it can his inheritance tax allowance not only covers the 3.6 million, but also another 325,000 of value, which in that example, that scenario would mean that there would be 75,000 subjected to inheritance tax. And it ends up being a decision best made, best taken at the time, having with the trustees and the family having the full power to make an informed decision. But the upshot is it might be still sensible to pay a little bit in the way of inheritance tax. So to pay 30 odd thousand pounds in inheritance tax for the benefit of the 3.2 million inheritance tax that I described. But it's a good question because it is an issue you do have to deal with and you do have to think about. But you incorporate, the answer is you incorporate the flexibility to be able to make the best decision, taking into account the circumstances at the time. So another question I've got is, do I think if more and more clients use double dip planning, it could be a catalyst for changes to business relief more widely? I mean, double dip planning, not in the sense of the single trust that I described today, but double dip planning has been around for many years. It's been available for many years. I'm still not aware of that many clients who have ultimately implemented it, and put it into action. We do know that the government are considering changes to inheritance tax and changes to capital gains tax. You know, we've had recently the OTS's reports, and one of the items that they cover off is the incredibly generous business relief provisions that do apply, especially when they interact with capital gains tax. So when you get an uplift for capital gains tax purposes on death, and you get full relief for inheritance tax purposes. So my personal view is it wouldn't surprise me to see some form of changes in that arena in the not too distant future. But we've really got to plan with the rules that are in force at the moment. Okay, there is another one on there. Can I just walk through the inheritance tax position in John's death with 4 million business relief assets going into a trust, accepted exempt, but the 4 million life interest for Jenny, no entry tax. I think what that's getting at is just, can I explain? And if I go back to my slide, which just explains that the investments are going to pass into that sub-fund 2, that life interest. The reason those investments, and indeed the property, aren't subjected to inheritance tax is because spouse exemption will apply. And that's because that life interest in favour of Jenny is treated as what's called a qualifying interest in possession settlement. It's an immediate post-death interest, is the technical terminology from an IHT perspective. So Jenny is treated as owning those funds for inheritance tax purposes. So the spouse exemption rule applies in full. So that's why there is no inheritance tax loss at that stage. I am now very conscious of time. There are a few other questions. We will endeavour, those that have included their name against them, we will endeavour to get in touch with them. I do hope you found the session useful this morning. We will be sharing the slides with you, as I mentioned at the outset, and there will also be, I should just highlight that there's the Protecting Family Wealth session on the 8th of July, which is the next in our private wealth series of webinars. And you will all, hopefully, when you sign out of this session, you will see a feedback form. Please do spend a minute or two, it is only a minute or two, filling that in. That really does help us in terms of understanding what you felt about this session and us piecing together future sessions that may be of interest to you. So thank you very much from me. I hope everybody has a fantastic day, and we hope to see you all soon. Thank you.
Thank you. Bye.